person is presented before a court without being formally charged and is thereby informed of the reasons for his continued detention through the state's application, like ours, to have him so held, the state must satisfy a double test. A. First, the state must persuade the court that it is acting in absolute good faith and that the continued detention of the individual without a charge being preferred, whether provisional or otherwise, is inevitable due to existing exceptional circumstances. So that through the factual matrix, we are going to establish exceptional circumstances. And B, this is the second part of the test. Second, the state must demonstrate that the continued detention of the individual without charge is the least restrictive action it can take in balancing the quadruple interest. This is very interesting. Quadruple interests present in a potential criminal trial. There is a potential criminal trial, and this is the quadruple interest. Number one, the rights of the accused individual, in this case the respondent, who is likely to be charged in a potential criminal trial. Number two, the public interest, order, and security. It is not in doubt that this is one of the matters of the greatest public interest in the country at the moment. Number three, the needs to preserve the integrity of the administration of justice. We will discuss that in a minute. And finally, and the interests of victims of crime where appropriate. And Your Honor, the court, in cracking its head about it, continues to say, by virtue of Articles 21(1) and 259 of the Constitution, the court must act to aggrandize, not diminish, the personal liberties of arrested individuals in line with the other three interests. But importantly, differently put, the state must demonstrate that there are compelling reasons to deny pre-charge bail, while balancing all factors within the complex permutation presented by these quadruple interests, and without reifying or essentializing any. I dare say kizungu kubwa. Having highlighted those two tests, Your Honor, the state is acting in utmost absolute good faith to have presented the respondent within a reasonable time before court. Other than in the police cells, through the affidavit before you, the respondent has been informed, one, of the reason of his arrest, and two, of the reason why the state seeks to continue to detain him. That is a show of utmost good faith. You know, in insurance law, it's called uberimai fidei. That good faith is furthered by the fact, as my learned senior will tell you in the facts, or rather in the affidavit, that there has been some investigations ongoing, and that we just need a limited period within which to complete those investigations. And finally, from my part, in compliance with the need provided for under Article 24 of the Constitution, that the limited detention of the respondent is the least restrictive measure we could adopt to protect both the interests of the respondent, the victim's interests, and as equally important, the interests of the public to ensure safety and security. You know, with that legal background, I invite my learned senior, Mr. Jalson Makori, to take you through the factual matrix in the affidavit. I am most obliged unless there's a question for me.
All right, thank you.
Thank you.
Your Honor Makori. Your Honor, we are referring to the affidavit by one Abdurrahman Jibri. Abdurrahman Jibri, dated the 16th of June 2025. It is an affidavit in support of the notice of motion, dated the 16th of June 2025. Your Honor, I will only highlight the paragraphs that are in the affidavit. Paragraph 6 sets out the background of the investigation, and these are the preliminary investigations by IPOA, which reveals in paragraph 6A to E, 6A to E, that is on the 4th of June 2025, the DCI received a complaint from the DIG of police, Mr. Eliud Langat, alleging he suffered continued false and malicious applications on an X account, formerly Twitter, with the username Pixel Pioneer, and requested investigations with a view to establish the person and motive behind it. Your Honor, A to E establishes the grounds in which the investigations were mounted. It is at paragraph 6D. On the 7th of June, the DCI team went to Linda Center in Homa Bay County and arrested the deceased at around 2:30 p.m. And they took him to Mawengo Police Station, placed him in custody with the OB number 10/7/6, 2025.
Read it again. 10/7/6.
That is 10/7/6, 2025. Then at around 3:54 p.m., the deceased was booked out under OB number 11/7/6, 2025, and escorted to Nairobi, where he was booked at Central Police Station under OB 136/7/6/2025 at 9:32 p.m. Your Honor, we have annexed to paragraph 6E the OB extract, that is AJ1, indicating the time that the deceased was booked at Central Police Station. Paragraph 7, Your Honor, the respondent was arrested, and this is something that would wish the court to take notice. The respondent was arrested on the 13th June 2025 at 18:05 hours, that is 6:05, which was on a Friday. The respondent in paragraph 8 was informed of the reasons of the arrest and for which and the reasons and of the offense that is being investigated. That is under paragraph 8. Your Honor, in paragraph 10, now we are coming to the reasons why we want to continue holding the respondent. The respondent is the custodian of the station records, being an OCS, officer commanding station, and the surveillance system, the CCTV. And this is at the material time under the investigations.
What will be the respondent telling us?
Your Honor,
the information the DPP is giving, it's not the one who deformed. It is the one who deformed who should be giving us those paragraphs.
We can talk about it because the
then
matter
the
is here.
DPP can trust their submissions based on that. Right now, the DPP is turning himself into a witness.
No.
We cannot cross-examine the DPP. It is fair and just. The witness who deformed takes us through his entire.
Your Honor, as I said that I'll only highlight a few paragraphs which I wanted the court to take note of.
You know, that's a
because
it's a dicey situation because
yes,
you're literally taking us through the but I leave because I'm sure you have your own strategy.
Yes.
On how to execute the application.
The defense
of to details.
Yes.
Of the fidelis, I'm sure
Why not?
The ones
have
a chance.
Yes.
So I'm making but I don't go too much into it. Position.
You can hit this one.
No, Your Honor, I'm only highlighting some paragraphs. I'm not going through the whole affidavit because they have already indicated that they want the deponent on the dock for cross-examination. Yes. Your Honor, what we are... Yes, the CCTV, yes, we say paragraph 10, the respondent is the custodian of the station records and the surveillance system, that is the CCTV, that is under investigation. Yes, investigations reveal that under paragraph 11, that the respondent, together with others who are not before court, hired a technician to interfere with the CCTV system at the Central Police Station in a bid to tamper and interfere with the subsequent investigations.